the Judicial and Bar Council. This allegation was corroborated by retired Justice Brion when he narrated his dissenting opinion in the case of Hardelesa versus JBC, where he claimed that respondent circumvented the rules and regulations of the JBC when she became the accuser and the judge in challenging the integrity of Justice Hardelesa. The document used by respondent in accusing Hardelesa, according to the latter, was highly classified since it involved privileged communication and work product among the legal team of the Republic in the arbitration case. When Chief Justice Sereno used this document against then Solicitor General Hardelesa, and in the borrowing the words of Justice Hardelesa, the Chief Justice was the one who committed treason. Initial clarificatory questions were also raised on the issue that Chief Justice Sereno manipulated by the JBC by utilizing the clustering scheme in coming up with a short list of nominees. As Justice De Castro already imparted to the committee, the Supreme Court justices made a unanimous decision declaring that the clustering scheme utilized by JBC is unconstitutional. However, it is very apparent that there was an effort to use this clustering scheme to favor certain nominees and disenfranchising others. Since the clustering of nominees was arbitrary and without any factual or legal basis, I believe this matter will again call for the invitation of Justice De Castro to further clarify the matter. Lastly, the impeachment committee has also covered the allegation that respondent lied to other justices of the High Court to do away with the voting for the recommendees to the vacancies in the Supreme Court. It appeared from the testimony of Justice Brion that the judicial screening process was manipulated and that then sitting justices of the Supreme Court were made to believe that some justices requested no longer to recommend for vacancies when in fact none of them made such request. From all the discussions and clarificatory questions, more or less the impeachment committee is almost finished with the first two grounds for impeachment alleged in the complaint. Hopefully, we will be able to finish the other allegations under corruption by next week before we proceed to the two other grounds for impeachment, which are other high crimes and betrayal of public trust. So just to give you a way forward to these impeachment hearings, the committee intends to complete these probable cause hearings by the end of February, and if time will not permit this, probably at the latest by the first week of March. Thereafter, we will submit the report for approval of the plenary before Congress goes on a Holy Week break in March. From now until said deadline, the impeachment committee will continue to conduct hearings for clarificatory questions to fully cover the first two grounds, and then we will proceed with the other two grounds. On the ground of other high crimes, there were 4 acts charged against Justice Sereno. One is obstructing justice by ordering the judges in Muntinlupa RTC not to issue warrants of arrest against Senator Laila M. De Lima. Second, obstructing justice by meeting the presiding justice and associate justice of the Court of Appeals and instructing them not to comply with the show cause order of the House of Representatives and to immediately file a petition for prohibition before the Supreme Court. 3, failure to report in her SALN and tax returns and to pay the appropriate taxes from her attorney's fee she received as counsel in the Piatco case. And 4, embellishing her personal data sheet in her application to the judiciary by overstating her credentials. On the ground of betrayal of public trust, 9 acts were attributed. One is, first is hiring IT consultants with excessive compensation without public bidding. 2, sending an inappropriate and strongly worded letter to the President regarding the judge's link to drug lords. 3, preventing justices of the Court of Appeals from making a courtesy call to the President. 4, attacking the imposition of martial law during a speech while the issue is still pending before the Supreme Court, and later continuing to participate in the court's deliberation on the same issue. 5th is issuing a statement with the presiding justice of the Court of Appeals on an issue pending with the CA, which could still be appealed to the Supreme Court, where the Chief Justice may also participate. 6, practicing favoritism by allowing key positions in Supreme Court to remain unfilled in order to wait for her staff to qualify, to the detriment of the service and demoralization of qualified employees. 7th is appointing a key official without authority or approval of the Supreme Court en banc. 8, granting newly hired staff foreign travels and travel allowances without authority or approval of the Supreme Court en banc. And 9, usurping the mandate and powers of the Supreme Court en banc, arrogating unto herself the administrative manage of the Supreme Court and the judiciary, thereby destroying the Supreme Court as a collegial body. As resource persons for the remaining undiscussed issues, the impeachment committee will invite Justice De Castro, Justice Mariano del Castillo, Justice Andy Reyes, CA Justice Remedios Salazar Fernando, retired Justice Adolfo Ascuna, and other court officials. The impeachment committee likewise intends to invite the psychiatrist who gave failing marks on the psychiatric or psychological makeup of the Chief Justice and who were allegedly fired or whose contracts were not reviewed or renewed upon the assumption of the Chief Justice. For today, 3 more justices, 2 of whom are the more senior members of the Supreme Court, have taken their time off to honor this committee with their participation to assist in ascertaining whether there is factual and legal basis to impeach the Chief Magistrate. We have invited the following resource persons: Associate Justice Samuel Martires, who will elaborate on his penned decision approving the petition for retirement benefits of judges and justices and the surviving spouses of judges and justices, and on the internal rules and procedures of the High Court. Associate Justice Luke Bersamin, one of the more senior members of the Supreme Court, will clarify matters pertaining to the alleged falsification of the TRO in the Senior Citizens Party List case, and on the internal rules and procedures of the court, and on the allegation that the Chief Justice misrepresented to other magistrates to do away with the voting for the recommendees to the vacancies in the Supreme Court. Associate Justice Dado Peralta, another senior member of the High Court, will testify on aspects on the alleged delay on the transfer of Mauti cases, also on the alleged falsification of the TRO in the Senior Citizens Party List case, the embellishment of CJ Sereno's personal data sheet, and alleged manipulation of JBC processes. The committee also sent an invitation to Senior Associate Justice Tony Carpio, who in a formal letter politely declined the invitation, citing lack of personal knowledge of the topics he was asked to testify on. On administrative matters, before we start with the hearing, let me just go through some of the administrative matters on the impeachment hearing. On the issued show cause orders, last year, this impeachment committee issued show cause orders to attorneys Joshua Santiago, Aldwin Salumbides, both spokespersons of Chief Justice Sereno, and also Commissioner Roberto Cadiz of the CHR. This committee already received the letter explanations of all three, and we have referred the matter to Congressman Ching Veloso and Congresswoman Gwen Garcia, who will submit their recommendation on the matter. On the issued subpoenas, I believe that all concerned parties have complied except for the BIR, which according to the authorized representative who appeared before us, needed more time to gather subpoenaed documents and to submit the same together with its report to the committee. Therefore, I direct the committee secretary to follow up the matter with the BIR. On a final note, I'd like to take this opportunity once again to commend all the justices of the Supreme Court who appeared before this impeachment committee, as well as all other resource persons who participated in these proceedings. Let us continue to remain faithful to our sworn constitutional duty and to our distinguished members now acting as investigating prosecutors as we ascertain probable cause to impeach the Chief Magistrate. Let us stick to the facts and refrain from raising personal questions immaterial to the issues at hand. I encourage everyone to remain objective in performing our constitutional mandate to determine the fitness of the Chief Magistrate to continue holding her high office and lead the third branch of government, the judiciary, and deliver the justice to which is the people so deserve. Let us maintain the respect and candor that should be observed in the impeachment proceeding. May we have a fruitful hearing today and a great year ahead of us. Happy New Year to everyone. At this juncture, may I ask the COMSEC to acknowledge the members present and the resource persons and guests invited in today's hearing.
Good morning, Your Honor. The committee acknowledges the presence of the following members: the Honorable Chairperson, Reynaldo Umali; the Honorable Senior Vice Chairperson, Vicente Veloso; the Honorable Members, Rosemary Baby Arenas, Ramon Ravro Camora, Davina Grace Yu, Carlos Roman Uybareta, Mahmoud Mending Jr., and Romeo Acop. We also have ex-officio members present: the Honorable Deputy Speaker, Gwendolyn Garcia; the Honorable Majority Leader, Rodolfo Fariñas; the Honorable Senior Deputy Majority Leader, Juan Pablo Bondoc; the Honorable Deputy Majority Leaders, Ann Hofer, Vincent Casologo, Victoria Isabel Noel, and the Honorable Deputy Minority Leaders, Alfredo Garbin Jr., Eugene Michael De Vera, and Anthony Bravo. And a guest member, we have the Honorable Mark Go. The committee also acknowledges the presence of the following resource persons invited. We have the complainant, Attorney Lorenzo Gadon. We have Associate Justices, the Honorable Diosdado Peralta, Lucas Bersamin, and Samuel Martires. And we also have the Honorable Court Administrator, Jose Maidas Marquez. The committee also acknowledges the presence of the Honorable Court of Appeals Justice Audrey Peralta, the wife of the Honorable Justice Diosdado Peralta.
Mr. Chairman, Mr. Chair.
Please, the Honorable Senior Majority Leader.
Mr. Chair, I would just like to ask if the respondent, Chief Justice Sereno, is represented by counsel today.
May we know if any of the lawyers of the Chief Justice is around? And please identify yourself for the record.
Your Honor, Attorney Carla S. Pingol from the counsels of the Chief Justice.
What's the pleasure of the Deputy Majority Leader?
Sir Chairman.
I'm satisfied, Mr. Chair.
I did not. I was not able to hear. But do you? Are you from the Supreme Court, from the Office of the Chief Justice, or are you a private counsel of the Chief Justice?
Your Honor, I'm one of the private counsel as appearing in the special power of attorney of the Chief Justice. Private counsel, Your
You are
Honor.
a private counsel,
Yes, Your Honor.
not from the Supreme Court.
Not from the Supreme Court, Your Honor.
Thank you very much.
Mr. Chairman, good morning.
Kanino yun? Sino yun? So, any more points that any member of this committee would want to raise?
May we know, Mr. Chairman, who are the invited guests for this particular year, and who were not able to come? Yes, and who are the invited guests? How many invited guests do we have?
I believe it's only Justice Carpio who politely declined.
Only Justice and the Chief Justice, of course.
Yes.
Thank you very much, Mr. Chairman.
Asan? Ready ka na sa trabaho? Okay, Attorney Gadon, let us give more time to the resource persons who were invited. No? So we would like to know, Your Honors, if do you have a prepared statement or an affidavit so that the members will be guided as to the matters that you'd like to convey to this committee.
Mr. Chairman.
No more, Your Honor. Mas maganda yung extempore in Diyos kasi come from the heart eh. You prepared the statement, marami kang makakalimutan eh. But you ask a lot of questions like these proceedings. Lumalabas yung hindi mo sinulat eh. So,
Thank you for that. So that goes also for the other resource persons.
Yes, Your Honor.
Congressman Garbin.
Thank you, Mr. Chairman. Para lang ho sa kaalaman ng mga naririto at nanunood na rin sa buong bansa, tayo ho'y in receipt of a letter from the Council of the Respondent, Chief Justice Sereno, informing this committee that she declined to be present or she declined the invitation of this committee to personally attend the hearing in today's hearing, Mr. Chair, despite the continuing invitation of this committee for her to appear and defend herself, Mr. Chair. So, ito po, at 10:11 this morning, this committee was in receipt of the letter informing this committee na ang Respondent Chief Justice Sereno continue to decline the invitation of this committee to personally attend the impeachment investigation.
Well, that is our lookout. As I've been saying, this is the proper venue to articulate her defense, not the media, because those manifestations or media statements will not matter to this committee, and only those that are recited here in the course of the hearing will be considered in resolving the issue on probable cause for her impeachment. So that is our lookout. I think the matter has been sufficiently explained, no less by the majority leader, as to how this committee will proceed in the absence of the Chief Justice herself. So she should be well-minded, even of the position taken by Justice, a sitting member of the Supreme Court, Justice Noel Tiham. And if she doesn't want to heed these advices, I guess this is really her character. Any other points before we proceed? So we will now proceed just to close this issue. Perhaps while Justices Peralta and Justice Bersamin are senior members, I think Justice Martirez is more senior. So we would give him
Correction, please.
in age.
In age, yeah, that's
in
correct.
age lang. More senior in age. So we'd like to give him the first crack at sharing matters pertinent to the issue at hand before this committee. But before we do that, may we ask our resource persons who have not taken their oath to please stand up, and I'd like to direct the COMSEC to administer the oath of our resource persons.
Good morning, Your Honors. Please raise your right hand and state your name for the record. Please state your name for the record, please.
Diosdado M.
Lucas
Peralta.
P. Bersamin.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
Yes, sir.
I do.
I do.
Thank you. You may take your seat.
So we now recognize Justice Samuel Martirez.
Good morning, Your Honors. I'd like first to clarify that I came here upon the invitation of this committee. I did not come here as the witness of Attorney Gadon. Contrary to what my friends in the media are saying, that I am here because I am a witness of Attorney Gadon. I came here because of that invitation that I could not refuse. I am just waiting for any question from any of the members because I do not know where to start. The only authority given to me by the NBank is to testify on administrative matters and probably with respect to the decision that I penned on the survivorship. So I am willing and just waiting sa mga tanong galing sa mga members ng committee.
We'll take the first crack, Congressman De Vera.
Thank you, Mr. Chairman. Good morning to my colleagues and, of course, to our resource persons, the justices from the Supreme Court. Since the Honorable Justice Samuel Martirez has already declared that he is willing to testify on his decision as far as the survivorship, doon po ba sa inyong desisyon po, ano po ba talaga yung pinaka laman nito na para anong basis para i-grant na po yung talagang retirement benefits po ng mga survivors, mga namatay na West?
Ang naging basehan lang ng desisyon ko ay yung batas, the law itself, na yung mga namatay bago naaprubahan itong batas na ito, before it became effective, at yung mga namatay, siyempre, after the effectivity of the law, are entitled, provided they have met the number of years required by law, which is 15 years. Yun lang ang pinagbasihan ko ng desisyon. Wala na hong iba.
So, yung pag-create po ba ng mga committees, yung mga technical working group para sa pag-i-evaluate po ng mga claims, ano po ba yun? Nakahadlang ba yun doon sa inyong sa ponente, sa pagkasulat nyo? Hindi.
This case actually, if I can only base my testimony on the rolio itself. This all started with a memorandum from the court administrator dated October 26, 2015 to the Chief Justice, recommending that yung mga namatay o yung mga judges and spouses ay bigyan ng prorata. Prorata rate lang sa pension benefits. Sa mga who died na wala pang, hindi nila na-meet yung number of years sa service. From that memo of the court administrator, nagkaroon ng report si Attorney Jocelyn Fabian, dated February 24, 2017, recommending for the denial of this recommendation of the court administrator, which memorandum to the Chief Justice was given to another technical working group who came up with their recommendation, which was submitted to the Chief Justice on July 11, 2017. Nang binigay kay Chief Justice yon, naraffle naman ho sa akin yung kaso noong August 7, 2017. Nailabas ko yung desisyon ng September 9. Yeah, September 9 ko na-promulgate yung desisyon. September 19, I'm sorry. But dahil sa, alam mo nyo sa Supreme Court, pagkakatapos sa desisyon ng isang kaso, where all the justices agreed with the ponente, this is a subject to further editing. Yung mga typo errors, kung tama yung mga footnotes, hindi lang ho yung justice yung ponente ang gumagawa. In the case of the division chair does the review also, and it goes also to the division clerk of court, nire-review pa rin yun, kasi baka may mga mali na dates. So, na-release lang ho itong decision na ito while this was promulgated September 19, na-release lang ho ito sometime on October 4. October 4.
Sa inyo bang pagkakaalala po, ilan po ba ang affected na mga beneficiaries po as far as yung kaso na yun na kayo po ang na-assign na writer?
I think there were more than 300 affected by this pending request for pension benefits.
Kailan pa ho nagsimula yung mga request po nila? Bago lang po ba yan? O siyempre iba-ibang dates po yan eh.
Mukhang matagal na ho kasi I think the request came after the effectivity of the law in 2010 of 9946. And this request came mostly from the justices or judges who died prior to the effectivity of the law. Katulad doon nila Justice Browner, yun ang mga ano.
So, ang nangyari po dyan, yung mga aplikante po na yan na affected ng inyong decision, hindi nila nakuha yung kanilang kanilang pension dahil disqualified po under po yung sa sinasabing pagkakaintindi prior po sa decision niyo po. Di ba po? Ganun po yun.
Nagkaiba-iba lang po ang opinion sa tatlong kaso na dinesisyonan ng Supreme Court. May dalawang kaso na like the Vilches case, binigyan ng lump sum, then later on parang, basta iba-iba yung naging opinion ng court. But the one that give us an idea na dapat halos bigyan lahat, pati yung mga namatay. Because at that time, death was not considered as a permanent disability or a compulsory retirement. Ay yung desisyon ni Justice Leonen na sinasabi niya, citing another decision also of the court, na wala ng ibang ng retirement ng isang tao, kundi yung namatay siya. There is no other permanent disability or compulsory retirement but death. So yun ho ang nagbigay din ho sa akin ng idea, yung decision po ni Justice Leonen, na dapat i-consider natin lahat yun, pati na ho yung to make a liberal interpretation of the law, na pati yung mga namatay prior to the effectivity of the law, basta they complied with the number of years service in the judiciary, ay bigyan ng full benefits. Ang pinagtatalunan lang po kasi, yung prior to the effectivity of the law, sinasabi po kasi ng isang grupo, ng technical working group, na hindi na dapat bigyan yung mga asawa, yung mga survivors, ng pension benefits because the pension benefits pertains to the justice or judge. Pero ang pinag-uusapan nyo dito kasi hindi yung pension eh. It's the survivorship benefits that is provided for by law. So, doon lang ho ang pinagtatalunan. Wala namang masyadong problema. Kaya nang binigay ko ito sa NBank, on that same date, we called it anonymously approved. Except for 3 members of the court, Justice Peralta, Justice Kagiwa, and Justice Leonen took no part because involved yung kanilang magulang sa retirement benefits na ito, survivorship benefits.
Sir Justice, doon po sa pagdinig nyo, no, doon sa pagsulat nyo ng inyong ponensya, napag-usapan din po ba dyan yung amount ng funds available para sa mga West? Kasi po siyempre, pagka hindi po nabayaran lahat yun, may matitirang pondo na unused. Nalaman niyo po ba kung gaano kalaking pondo po yan nalaan sa pension na yan po para sa mga survivors?
Alam niyo po, hindi po ako mahilig makichismis. Ang pinapakinggan ko lang pong chismis ay yung kay Deo Macalma at kay Arnold Clavio. But in this case, all I ask from the finance officer of the Supreme Court and the Court of Appeals and the Sandigan Bayan, mayroon bang pera pambayad? At iisa lang ho ang sagot nila, mayroon. So dahil sa may perang pambayad, wala hong problema pag pinagbigyan namin lahat. Pero kung magkano yung pera nandoon, yun po ang hindi ko alam.
So, aware po ba rin kayo, Justice, na yung pension fund na yan para sa survivors, hinihingi po yan dito sa Kongreso under the General Appropriations Act?
Alam ko po yun. Pero kung magkano po yun, hindi ko po alam. I was not concerned on the amount. I was more concerned on whether we can pay. Kung mababayaran namin itong mga retired judges or justices o yung mga asawa ng mga namatay na mga huwes o miyembro ng judiciary. That was my only concern.
Justice, may 2 years po na na parang 2 years po yung period na hindi nagbayad ng survivorship pensions po, di ba po? Siyempre po, may naitanong niyo po ba kung magkano yung savings na during that time nung hindi binayaran, yung mga may idea po ba kayo doon sa savings?
Kinalulungkot ko po, sabi ko nga po, pagdating sa mga ganong bagay na wala na masyadong kinalalaman sa desisyon ko, hindi na ho ako nagtatanong. Because the only thing that mattered to me is, mayroon bang pera tayo na nakalagay sa ating appropriation na kayang bayaran itong mga claimants na mga asawa ng mga namatay na mga mahistrado.
Just to conclude, Mr. Chairman, kaya ko lang po natatanong yan kasi under the General Appropriations Act po, ang aking pagkakaintindi, pagka may savings po, yung head of agencies kagaya na ino-authorize to realign funds for augmentation for other expenses within the offices, gaya ng the President, the Vice President, the Senate President, the Speaker of the House, and even the Chief Justice, may realign po yung savings. Kaya ko po natatanong kasi sayang po yung pera Alangan naman na isoli ulit, kaya nire-realign sa ibang expenses. Yun lang po yung aking gustong sabihin kasi meron naman, kasi yung nga, ano nangyari doon sa savings? So siguro sabi nyo, hindi nyo naman masasagot. Tinatanggap ko po yun. At siguro nga, hindi na pag-usapan doon sa kaso.
Ang makakasagot lang po ng katanungan nyo ay yung aming Chief ng Finance, Attorney Flores. Kung anong nangyari sa savings. Saan napunta yung aming savings? Paano na-realign? Was it approved by the NBank or not? Hindi ko masasagot yan.
That will be all, Mr. Chairman. Thank you.
Thank you.
Thank you, Justice.
Perhaps this will be relevant when the Supreme Court submits its budget during the budget deliberation. Congresswoman Garcia, Deputy Speaker Garcia.
Thank you, Mr. Chairman. And good morning to the Honorable Justices. My question to Justice Martires would be, first, as a matter of clarification, you had already stated this. The decision that you had penned September 19, 2017 involved, in fact, 3 cases. One, which involved the case of Mrs. Pasita Gruba, the surviving spouse of the late Manuel Gruba, former CTA Associate Judge. The second involved the case of Mr. Salvador Vilches, surviving spouse of the late Deputy Court Administrator Nympha Vilches. And the third involved the claims of those spouses of judges and justices that had died prior to the enactment of Republic Act 9946. Am I correct, Honorable Justice?
Yes, Your Honor.
And in this particular, and may I just focus our attention on the third case, because this involved quite a number of surviving spouses that had already filed their claims and for which quite a long period of time had passed before this decision was finally handed down. So if we focus on the survivorship claims of the spouses of judges and justices that had died prior to Republic Act 9946, Justice Martires, there were in fact 2 memoranda that were submitted for your consideration. And both memoranda emanated from the same special committee for retirement benefits. Is that correct, Mr.
Yes, Your Honor.
Justice?
Yes, Your Honor.
And both memoranda were at opposite ends.
Yes, Your Honor.
On the survivorship benefits being claimed, Memoranda A recommended for the grant of these benefits.
Yes, Your Honor.
Memoranda B, on the other hand, adopted the position that these benefits should be denied.
That's correct, Your Honor.
I would just wish to ask, Honorable Justice, if both memoranda came from the same committee, did it ever occur to Your Honor why there should be conflicting positions coming from the same TWG of the same committee? And in fact, Memoranda A, which recommended for the grant of these benefits, carried with it the majority vote of the TWG. Am I right, Honorable Justice?
That's correct, Your Honor.
And that Memoranda B represented the position of the minority.
Yes, Your Honor.
So did it ever occur to you, Your Honor, why there should be two conflicting positions coming from the same TWG, from the same committee, which under normal and correct circumstances, by rule of majority, should uphold the position of the majority? Would it not be so, Your Honor?
Kung titingnan po natin yung composition ng committee, lahat po sila ay mga abogado. At lagi ko pong sinasabi na pag naglagay ka ng 1,000 abogado sa isang lugar, magkakaroon ka ng 1,000 iba't ibang pananaw. Lagi kong inahalimbawa ang bote nasa harap ko. Pag tinan mo isang abogado, ibang kanyang pananaw kung anong klaseng bote ito. Different views. And it was expected from this committee, composed of 7 members. I'm sorry, 8 members, na nagkaroon ng parang dissenting opinion. When the 5 members, the vice chair, si Attorney Candelaria, ay nag-submit ng Memorandum A, pinirma nito nila Attorney Flores, Regina, Ignacio, Attorney Pabelio, and Baribalco. Subalit ang chair, si Attorney Gombio, ay nag-dissent. At sumali sa kanyang dissenting sila Attorney Villanueva at Attorney Fabian. It was understandable for Attorney Fabian to dissent dahil yung kanyang memorandum ng February 24, 2017, sinasaad na niya roon na dapat i-deny ang mga to. So kumbaga doon sa Committee of 8, isa na doon ang hindi sasang-ayon sa inirekomenda nila Attorney Candelaria. Sumali na lang yung dalawa sa kanya, si Attorney Gombio at saka si Attorney Villanueva.
Si Attorney Fabian po, would you know, ano pong position ni Attorney Fabian, aside from being chair of the legal TWG po?
Aaminin ko po sa inyo na kahit magbanggaan kami ngayon ni Attorney Fabian, hindi ko po siya kilala. But based on the records, I found out that her position in the Office of the Chief Justice is Court Attorney 6. Court Attorney 6. Yung po ang pinakamataas na posisyon sa mga office ng justices.
So she is from the Office of the Chief Justice?
Yes, Your Honor.
And Attorney Gombio and the other, maybe...
Attorney Gombio is now the Assistant Clerk of Court. I don't know about Attorney sa Monte Villanueva. Itong dalawa po, kilala ko. Pero si Attorney Fabian, hindi ko po kilala.
So that, yung tanong ko lang nga po kasi, totoo talaga, ang daming abogado, ang daming mga opinyon. Kaya nga po, hindi ba, kahit nga hindi abogado pero mas lalo na kung mga abogado. Kaya nga po, pag mag-create ka ng committee, by virtue of a memorandum, siguro, as we follow all the normal procedures of how business is conducted in any committee, or in any company, or in any organization for that matter, kaya nga po siguro pag nagkakaiba-iba yung mga opinion, it's called to a vote po, hindi po ba?
Opo.
At pag it is called to a vote, siguro yung sinusunod talaga natin po, kasi what does it matter kung ba't pa tayo magbobotasyon kung yung majority pala hindi pa rin magiging prevailing position ng komitiba na yon. Tama po ba?
Kahit po naging unanimous sila, the recommendation of the committee will still be approved by the NBank. It will still be submitted to the NBank. The case will still be docketed as an administrative matter at yun po ay iraraffle sa isang justice para po desisyonan kung tama po yung recommendation ng committee o hindi.
Opo. Kaya nga lang, pag unanimous, pag wala ng dalawang memoranda, hindi na kailangan i-resolve yung conflicting positions po. At siguro, ano na lang, it would be a matter of an unbank recognition of that position and resolution. Because all final resolutions naman are vested on the unbank po.
Karamihan po ng nire-recommend ng Office of the Court Administrator o ng mga committees, normally, ina-adapt ng NBank. But in this particular case, kahit po yung majority, ang kulang po sa kanilang memorandum o sa kanilang pag-aaral, hindi nila naisama yung death, yung pagkamatay ng isang maestrado while in service. Yun po ang isang bagay o aspeto na wala doon. So kung sana kumpleto po yung kanilang ginawa sa kanilang memorandum, I think I would just have recommended as C resolution. Hindi ko na po kailangan sumulat pa po ng isang desisyon dahil ang daming English po na ginamit ko rito medyo mahirap po mag-Ingles dahil Bisaya po ako
Ay, salamat. Magkasabot gid ita. Nevertheless, Your Honor, you did adopt the position of those taken as submitted under Memorandum A, which was to grant the benefits for surviving spouses of those judges and justices that had died prior to Republic Act 9946, and further enhanced it by including those judges that had died while in active service, because death is the final retirement po, as we can call it.
Yes, Your Honor.
I am so glad that you mentioned this po, na karamihan ng rini-recommend ng court administrator prior to the creation of the special committee would be upheld or adopted by the unbank. And so for this reason, if with the permission of the chair, may we just request the court administrator Maidas Marquez to kindly refresh the minds of the committee members, and more especially the public, as regards previous claims or previous cases that were accepted by the Office of the Court Administrator prior to the creation of the special committee created by virtue of a memorandum signed by the Chief Justice.
Thank you, Your Honor.
Yes, you're recognized.
Okay. Magandang umaga po sa ating lahat. Tama po yung sinabi ni Justice Martirez. No? Gusto ko lang pong liwanagin or linawin na yun pong ang pinag-uusapan po, no, bago for those who are asking for retirement benefits, no, bago na isabatas yung survivorship law on February 11, 2010. Okay? Dalawang klase po yun. Yung isang klase po ay yung nakapag-serve na ng 15 years. No? Doon po sa mga nakapag-serve na ng 15 years, tapos namatay po yung judge or yung justice bago February 11, 2010. Wala pong issue doon. Lahat po yon in 271 instances in the past. The court granted survivorship benefits to the surviving spouse. So wala pong issue doon. Kasama po doon yung nabanggit ni Justice Martirez na parents ng tatlo nating incumbent justices.
Ulitin ko lang po, ibig sabihin, kasi survivorship benefits itong pinag-uusapan natin. Yung 271 cases involved judges and justices na namatay prior to Public Act 9946 but had in fact served 15 years or more.
Yes, Your Honor.
And in all of these 271 cases, ano po yung recommendation ninyo?
That they be given retirement benefits, effective survivorship benefits, effective upon the effectivity of the law, which is on February 11, 2010. Kasama rin po yon sa desisyon ni Justice Martirez.
So in these 271 cases, 271 times inadopt yung recommendation ninyo ng Supreme Court.
Yes, Your Honor. At dagdagan ko pa po yun. Kung maalala po nating lahat, nagbigay po ako ng kopya ng aking liham, dated January 12, 2017, following up this matter, and I listed 29 claimants because as of January 12, 2017, these 29 claimants, their applications have been pending for more than a year and a half already. Because of the decision of Justice Martirez, of the 29 claimants, yung 26 or 25, lahat po yan first and second level courts, approved na po ng courts, ng Supreme Court, in the same manner that the 271 applications have been approved.
In other words, balikan natin, itong 29 claimants na pending yung claim nila under the committee, special committee on retirement benefits for a year and a half or even more. Yung kaso po nila were exactly the same circumstances of the 271 other cases that had previously already been approved, adopted by the Supreme Court at recommendation po ninyo na bigyan po. So there was no question. In other words, yung situation ng 29 cases na to, this involved judges or justices who had died prior to February 11, 2010, had served 15 years or more. Tama po ba?
Tama po, Your Honor. Ang isa pang issue na binanggit po ni Justice Martirez earlier are those judges or justices who died prior to the effectivity of the law but has not served 15 years or more. Yun po yung may issue. Kaya po nung October 26, 2015, katulad po ng nabanggit kanina ni Justice Martires, meron pong recommendation ang Office of the Court Administrator to give them prorated benefits kasi nga po hindi sila nakapag-serve ng 15 years or more. Doon lang purong merong issue. Pero ang nangyari po, pati po yung 29 cases na binanggit ko doon sa aking liham, isinama. So yung 29 cases na yon na dapat walang issue, yon ang tumagal ng more than a year and a half, almost 2 years or even more for the others.
So that in other words, hindi pa na-resolve talaga yung kaso ng judge who may have died while in active service prior to February 11, 2010 and had not served 15 years. Hindi pa yon. Wala pang decision, wala pang previous case nun na inadapt yung recommendation ninyo.
Yes, Your Honor. Doon po yung may valid issue kasi wala pa po tayong maliwanag na jurisprudence on that. Kaya yun lang po dapat ang dinesisyonan ng court. Because prior to that, as we have mentioned, and even as included in the decision of Justice Martires, for all those who have served more than 15 years or more, but they died prior to the effectivity of the law, their spouses were given survivorship benefits.
So the issue here really revolves around the 29 cases.
Yan, I would like to think so, Your Honor.
Because yung circumstances po nila,
maliwanag na maliwanag
tamang-tama po, angkop na angkop doon sa circumstances ng previous 271 other claims.
Yes, Your Honor. Wala pong pagkakaiba po yun.
Na nagsabi na ang Supreme Court na bigyan sila.
Tama po yun. At yun din po ang naging desisyon ng Supreme Court through Justice Samuel Martires.
Thank you, Administrator Marquez. So, Your Honor, in truth and in fact, aside from the case of Vilches and the case of Gruba, the issue really just centered on whether or not, and this now sets it as a matter of norm, the issue really only involved the question of whether or not those justices that had died prior to the effectivity of Republic Act 9946 while in active service and had not served at least 15 years should also be entitled to the survivorship benefits, which 271 other claimants in the past had already enjoyed, but yung 271 nga lang, nakapag-serve ng 15 years or more yung judge or justice. Would you agree, Your Honor?
Actually hindi lang doon sa mga namatay prior to the effectivity of the law. Because in the case of Vilches, namatay po si Vilches after the effectivity of the law. Kaya lang, sinasabi lang nila, hindi pa siya due for retirement. She was not qualified. But Vilches has already served 22 years in the judiciary as a judge and as a deputy court administrator. So kumbaga pasok na si Vilches doon sa 15 years. Yet, dininay yung kanyang claim kasi ang sinasabi, bata pa kasi si Vilches, I think she was only 55 years old when she died. So sinasabi nila, hindi ka pa qualified mag-optional retirement.
Opo. Kasi nga, itong case ni Vilches and itong case ni Gruba, iba rin Magkaiba yung mga circumstances surrounding each of these two separate cases. However, in the case of 29 or more na nakapending in the special committee, this focused purely upon the survivorship benefits of the spouses of judges and justices who had died prior to the Republic Act 1946. So, my question po, taking aside or setting aside the specific circumstances surrounding the case of Vilches, the specific circumstances surrounding the case of Gruba, the issue really here, in the case of the third, itong pangatlong desisyon po ninyo, it really just determined the question on whether or not those judges that had died prior to 1946 who had not completed the mandatory 15-year term should, whether or not their spouses should also be given the survivorship benefits. Kasi po, in all previous 271 cases, hindi yan part of the circumstance. Kasi yung 271 po, kapag-serve naman. Hindi naman namatay within that 15-year term. So, the issue really was just on whether or not yung namatay na hindi nakapag-serve ng 15 years, may entitled ba yung spouses? Yun lang po, tama po ba? Am I right po?
Kasama po yun.
Kasi po, yung question ko lang po, and I don't know if you would wish to answer this, but we had already established na 271 times, nag-rule na po yung Supreme Court as regards those claims which involved the judges or justices who died but had already completed the 15-year mandatory period of service prior to 1946. Established na po kasi yun eh. Palagi na pong na-adapt over, may I ask, Mr. Chair, the court administrator, over what period of time all of these 271 cases had been upheld by the Supreme Court as upon your recommendation?
Your Honor, from the time the law took effect, which is in February 2010, until around 2014, from when the committee was created. Because at the time when the committee was created, natigil na po. Kasi lahat po ng recommendations ng Office of the Court Administrator with the same circumstances as those 271 cases were all referred to the committee.
And when this was referred to the committee, how long before the decision from the Supreme Court was finally handed down?
Well, following from
just refresh our memories.
Following from the testimony po of Justice Martires, the case was raffled to him only in August of 2017. And so, ibig sabihin po nun, sometime July or August, dun po ni-refer ng committee sa court and bank.
And yet, these claims had already been
pending
before the special committee since when?
Since 2014.
In other words,
up to 2017. 2015 to 2017.
Or an average of more or less 2 years.
Apa.
Ganun po, katagal. So,
yes, Your Honor.
Yung question ko po, Your Honor, Justice Martires.
Yes, Your Honor.
Na-establish na po kasi 271 times since the law took effect in 2010, na yung pong, hindi po yung mga namatay na hindi nakapag-comply ng 15 years, pero yung pong namatay prior to 2010, but had completed had served 15 years or more, talagang binibigyan na po yun. yung pong dating recommendation ng court administrator, each time upheld 271 times po. It was only the issue of whether or not yung mga namatay na hindi nakapag-complete ng 15-year mandatory period, ma-entitle pa rin ba yung survivors po or yung spouse. Hindi niyo pa, did it not strike you as perhaps a repetition or already a redundancy on your end that you must once again rule in favor or decide that these benefits be given to the 29, itong 29 po. Hindi po ba ito parang, ba't inulit pa to? May precedents na po. 271 precedents nga eh. Ano po ang, what crossed your mind po as regards these 29 cases na wala namang issue po doon?
Ang nangyari po kasi mayroon 3 kaso na magkaiba-iba ang opinion ng husgado ng Korte Suprema. The Vilches case, the Gruba case, and the Alvor case. All these 3 members of the judiciary died after the effectivity of the law. Vilches died in 2011. I think Gruba died in 1996. Except for Gruba, I'm sorry. Pero magkakaiba ho yung desisyon eh. It was only in Alvor, which was a decision of the division, na naging masyadong liberal ang husgado, ang Korte Suprema. In Vilches was only given a 10-year lump sum gratuity pursuant to Section 2. Wala pong survivorship benefits na binigay sa asawa ni Vilches. Kay Gruba, binigyan si Gruba ng 5-year lump sum gratuity. Pero, noong 2013, the court revoked the grant of survivorship benefits to Mrs. Gruba. Although hindi sa kanya pinabalik yun, yung mga natanggap niya dati, pero ni-revoke yung survivorship. Instead, the heirs were given or granted an increased 10-year lump sum gratuity. Pagdating kay Alvor ngayon, yung mga heirs, si Alvor only served the judiciary for 5 years and 4 months. Binigyan yung heirs ng 5-year lump sum ng Supreme Court at binigyan si Mrs. Alvor ng pro rata survivorship benefits. Na yun ang gusto sanang gawin ng court administrator na i-adapt sa mga ibang claims na yung mga hindi nag-comply doon sa a number of years of service in the judiciary of 15 years. Kaya dito sa 3 kasong ito, parang siguro nagkagulo yung isip ng technical working group, hindi ko alam. Pero ito yung nireconcile naming kaso.
Opo, tama po. Kasi hindi pa talaga, may issues po bawat isa. Magkaiba eh. Si Gruba, si Vilches, and even Arbor. Opo. Pero tanong ko lang po, kasi na-include din eh, sa 2 conflicting memoranda, na-include din itong 29 na well-settled na yung issue since February 10. Itong 29 na ilang beses, 271 times na po, nag-rule ang Supreme Court na bigyan ng survivorship benefits ang spouses ng mga justices who died prior to February 11, 2010 and had served in the judiciary for 15 or more years. Yun po ang circumstance ng 29 eh, na na-included po ngayon, na sinali po sa submission doon po sa inyo at naging part po ng conflicting positions of both memoranda. So, may I ask the Honorable Justice, let's take away the case of Gruba, Vilches, Arbor, which really needed a final determination. Pero itong 29 po, in your opinion po, kinailangan pa po ba ito na ma-include doon for the Honorable Justice to state, in fact, to uphold, in fact, what had already been upheld 271 times in the past. Kailangan pa po kaya ba ito? When there were other more pressing and in fact more complicated issues involving the other cases.
When I decide a case, whether it's retirement or not, I look into the totality of the case. In this particular situation, hindi lang ako concerned sa 29. Ang nasa isip ko po yung pangkalahatan na magkaroon po ng specific rules, whether the 29 is involved, the 307 is involved, the 100 pending, 100 applications pending with the TWG is involved. Ang akin lang ho, lahat po na nakapending yung mga applications for survivorship or pension benefits, ay ito na ho sana ang rules. So I did not discuss anymore about the 29. I did not talk anymore about the 271 times or cases that were approved by the Supreme Court. All I wanted was to set the specific rules or guidelines that will be followed in future claims of survivors or spouses of retired justices or judges.
Yes, thank you very much, Honorable Justice. But I cannot take away from my mind the 29 po. I understand and I commend your position that you take the entirety. No, you look at it involving, as submitted po to your office, all of these pending petitions, by the way, the 29 of which had been pending for over 2 years. Etong 29 po na my first question po, pag nadesisyonan na po ng Supreme Court prior 271 times, siguro that is always upheld kasi the first time it was decided, in-uphold the second time, the third. Kaya siguro din, in-uphold din ninyo. You also agreed.
Yes, Your Honor.
In the case of the 29.
Well, let me put it this way. Doon po sa 29 na pending applications which with the court administrator saying was pending at hindi po naaaktuhan, I think the best way, pinakamaganda po rito, ay sinasuggest ko, total, ang atin namang pamahalaan, gusto natin matino ang ating pamahalaan, I would rather ask those persons involved in these 29 cases that are already pending but was supposed to be approved. Why don't you just file the necessary administrative cases against any person of the Supreme Court who slept on his job, who was negligent? Kasi panahon na siguro para tayo linisin natin, hindi lamang ang ehekutibo o legislative department, but including the judiciary. We keep on hearing about judges being corrupt, but see who points a finger of corruption to that particular judge? Wala, puro takot eh. In this particular 29, siguro doon sa mga involved na mga ears nito mga judges, alamin nila saan nagtagal. At pag nalaman nila sino ang involved ng mga tao, but filean nila ang administrative cases. So that the Supreme Court also could weed out incompetent employees or negligent employees under the judiciary.
Your Honor, of course, the issue here is the impeachment of Chief Justice Reno. No? So yung other matters may be tackled in a different venue, not this. So let us try to stick to the issues.
Mr. Chair.
If I may just wrap up. Your Honor, I completely agree with you, but as the Chair had already stated, this is an impeachment hearing on the Chief Justice. And we are trying to establish here that there seemed to be a change of what had already been an established procedure, where the court administrator recommends to the Supreme Court the grant of survivorship benefits for those spouses where the judges and justices died prior to 2010 but had served for 15 years. And this is exactly the case of the 29. So, Your Honor, nung iniba po ito at binigay doon sa special committee, umabot po ng 2 years. And may I quote your decision po? Andito you did rule in, again, upholding for the 272nd time, we add probably plus 29, that these 29 spouses should be given the benefits that is due to them, contrary to Memorandum B, signed by 3, including Attorney Fabian, who is in the office of the Chief Justice, and including the Deputy Clerk of Court. Your decision stated, aside from granting these benefits, the surviving spouse shall continue to receive such retirement benefits until the surviving spouse's death or remarriage. Di po ba itong survivorship benefits po ay urgent in nature? Kasi nga po, itong mga spouses ng justices and judges that had died a long time ago are also in the twilight of their years and in much need, perhaps, of medical and other services, which such benefits would be of great help. And that, more importantly, if this spouse dies prior to the final determination of her claim, then wala na. Hindi na po yan maibigay sa, kasi it's a survivorship benefit nga po Kaya nga po, kung mamatay na yung nagka-claim, wala na po yun. Tama po ba? Tama po ba ako yun?
Lahat po ng usapin na kasama ho ang pera is very urgent in nature, especially pension. Dapat ibigay talaga kaagad. So I give this case priority na it took me a little more than 1 month kasi August sa akin na raffle and I was able to submit to the NBank on September 19. Binigyan ko ito ng prioridad. Kasi alam ko po na marami na pong mga tulad po ng asawa ni Justice Browner, asawa ni Justice Jurado, matatanda na po ito Ang mother po ni Justice Peralta, matanda na rin po. So, ibig sabihin, wala na ho itong mga ito, hindi na ho nagtatrabaho itong mga ito. Kahit po sabihin natin na sila may kaya sa buhay, iba pa rin ho yung may tinatanggap ka na buwan ng sweldo o pension. It gives you some kind of a dignity as a person na hindi ka umaasa sa iyong mga anak. Kaya minadali ko po ito.
Opo, and we commend the promptness by which you disposed or decided on the issues that were presented before you. And yet, for the 29 cases which were included po for your decision, 2 years po na nagmalinger po doon sa special committee, specially created nga, to focus nga lang sana on these retirement cases. And so, this does not cast any aspersion po on yourself, and in fact, we commend. Everybody is happy with the decision that you have made, but I don't think that the over 2 year delay would be accepted with the same joy by these spouses who, as I said, are in dire need. More for them. Everybody, yes. When we talk about money, it is urgent, but it is more urgent in their case.
Your Honor, Siguro mas importante dito, bakit nagbago yung policy and who caused this? That paved the way for these injustices to be committed against the beneficiaries. Yun ang siguro dapat tumbukin natin rather than the differences.
Opo.
Anyway, as you have already commended the justice for his swift decision-making, marami pong natuwa pero matagal pa rin na-implement. In fact, merong isa yata na nakamatayan na niya. That is now an issue. Is that entitlement still to be given to the heirs? The heirs is not the survivor. So, yun po siguro ang ating pag-usapan dito kasi that is where the problem lies. And who should be responsible for this? Yun po, and this is now the charge against Supreme Chief Justice Sereno because of the creation of this particular committee and technical working groups na nagbanggaan pa yung dalawa dahil hindi sila magkasundo. Pinilit ng minority yung kanilang position na nagdulot ng matagal na or nabinbin lahat ng yun siguro.
Mr. Chair.
Yes.
So, with the indulgence of our other colleagues,
please, you're recognized, Congress B.
So, Mr. Chair, umpisahan ko po sa napakagandang sinabi ni Justice Martires. Nung sinabi po niya na sana, doon sa naagrabyadong 29, o kung sino man pong naagrabyado sa husgado, sana po merong maglakas loob na maging complainant. Nang sa ganon, ang katiwalian po ay ating maituwid. Ay, nandito na nga po tayo. Meron na nga pong tumayo para buksan ang katiwalian o pagkakamalang ito. At yan po ang complainant na si Attorney Gadon. At dito sa kanyang complaint, ang kanyang sinasaad sa 4.4, ang respondent, si Chief Justice Sereno daw, ay gumawa ng culpable violation of the Constitution nung nag-delay siya ng aksyon tungkol sa retirement benefits and survivorship na pinag-uusapan natin ngayon. So meron na nga pong complainant tungkol sa nakikitang katiwalian. So, Mr. Chair, gusto ko po sana unang balikan ang pinaliwanag ni Court Administrator Maidas Marquez. At tatanungin ko po si Justice Martires kung yun po ang kanya pong pagkaintindi rin sa mga pangyayari na ipinaliwanag ni Court Administrator Marquez. Sa naintindihan ko po sa inyong panaliwanag, Justice Marquez, bago po na-create yung Special Committee on Retirement Benefits at yung dalawang technical working group, 2 to 3 weeks lang naayos nyo na ang problema. Pagkatapos nito, naging hanggang 2 taon ang pagdedesisyon. Tama po ba yung pagkaintindi ko sa pinaliwanag nyo, Justice Marquez?
Tama po yun, pero ang umaayos ng problema o ng issue, yung Supreme Court po. So nagbibigay po kami ng recommendation. After we give the recommendation, in 2 to 3 weeks, meron na pong resolution ang Supreme Court adopting our recommendation. At ito po nga po ay kabilang doon sa 271 previous cases.
Sige po. So, Justice Marquez, tama po yun. Dati 2 to 3 weeks, pagkatapos po ginawa yung Special Committee on Retirement Benefits at yung dalawang technical working group, umabot ng hanggang 2 taon, ayon sa inyo.
Tama po yun.
Justice Martires, kayo po ay naging ponente sa desisyon sa usaping ito. Ganun po ba rin ang intindi nyo? Bago po dumating ang Special Committee, natatapos po sa mga halos 2 o 3 linggo lang, at nung dumating na ang Special Committee, umaabot po ng hanggang 2 taon.
I was only appointed to the Supreme Court March of 2017. So anything that happened prior to that, I do not know. There is also nothing in the records about the creation or how the special committee or the technical working group was created. Kung sino ang nag-create itong technical working group, wala ho sa records. I only base my decision on the role.
Opo. Babalikan ko po kasi yung complaint ni Attorney Gadon. Nasabi niya, nagdududa sa mga naunang resolusyon ng Korte Suprema si Respondent Chief Justice Sereno, kaya gumawa siya ng technical working group na ang namumuno ay isang abogadong walang masyadong nalalaman. So, sino po ba ang naging head ng technical working group? Sino kaya ito pong abogadong walang masyadong nalalaman, Administrator Marquez, sa tingin mo? Attorney Gadon, kindly, sino po itong tinutukoy niyong abogado?
Yun pong si Attorney Gongyo at saka yun yung pinaka Chief of Staff ni Chief Justice Sereno.
Ako po ba tinatanong niyo, Attorney, kayo pong gumawa ng complaint. Sino tinutukoy niyong abogadong walang nalalaman?
Si Attorney Fabiano. Kasi
pakibigay po ang buong pangalan.
Jocelyn Fabian po. Kasi siya ho ay nag-join lang sa Supreme Court noong 2013. Kinuha lang ho siya ni Justice Sereno na despite maraming iba pang mga qualified employees sa Supreme Court, siya ho ay outsider at siya ang kanyang work experience ay accountant pala siya sa isang department store na nakasama niya sa religious organization si Chief Justice Sereno at yun ang naging daan upang siya ay mapunta sa Supreme Court. Kaya wala talaga siya masyadong nalalaman tungkol sa mga bagay na yan.
So kung titignan natin, ang nakasaad sa inyong complaint, dati mabilis ang proseso at yan ay pinatutuunan naman po ni Administrator Marquez, 2 to 3 weeks. Nung create yung special committee, pati na yung technical working groups, itong si Attorney Jocelyn Fabian naging head ng alin dito? Yung special committee o yung isa o pangalawang technical working group? Attorney Gadon.
Diyan, nung nag-testify ho siya dito, miyembro ho dyan sa 3 na committee. Doon ho sa special committee and then doon sa technical working
sabi niyo
group.
po kasi, headed by one of her lawyers.
Oo, siya nga po yan, si Attorney
So, alin pong hine-head niya?
Kaya, ang pagkakaalam ko po, doon sa testimony niya rito, doon yung 3 committees na yun, siya rin po yung head siya.
Tatanungin ko po si Administrator Marquez. Is si Attorney Jocelyn Fabian ho ba ang head ng Special Committee on Retirement Benefits?
Well, lumabas po doon sa, siguro to refresh the minds of everyone, no? Lumabas po doon sa testimony before na ang head ng committee is Attorney Gombio, yung ating Deputy Clerk of Court, and Attorney Fabian is the head of the 2 technical working groups. Yun din naman po ang sinabi ni Attorney Fabian, if I remember it correctly.
So, Attorney Gadon, lumalabas, hindi siya ang head ng 3. Head siya ng technical working group.
Ganun na nga po, Your Honor. Siyempre sa dami ho kasi ng mga issues na na-take up dito,
Apo.
wala po akong minutes na hawak ngayon.
Sige po. At dito naman po, paano, Attorney Marquez, paano na-create itong technical working group na headed ni Attorney Jocelyn Fabian na tinutukoy dito sa complaint na abogado na walang masyadong nalalaman at marahil isang dahilan kung bakit umabot sa 2 taon ang bagong proseso nung dati ay 2 linggo lamang.
Base
Sino
rin
po na-create ng technical
base rin po doon sa mga nauna nating mga pagdinig, no? Katulad po na sinabi nyo, bago po na-create yung committee at 2 technical working groups, pagkatapos po ng recommendation from the Office of the Court Administrator, ito po ay pumupunta sa Office of the Clerk of Court and Bank for raffle to the member in charge, no? So after the raffle, it is brought to the
Justice Maidas, I hope you don't mind me cutting you off. Hindi po yon, sir. Sino po ang nag-create nung special committee for
sige po,
retirement benefits and yung technical working group? Sino po nag-create yan?
Sagutin ko po. Ang nag-create po ng committee yung 3 senior justices, Chief Justice Sereno, Justice Antonio Carpio, at Justice Presbiterio Velasco. And then, under the 2 committees, under the committee are 2 technical working groups created by the Chief Justice, approved by the Chief Justice, the creation of the TWG.
Sino po nagrekomenda ng creation ng technical working group, Justice Marquez?
Yung committee po ang nag-recommend for the creation of the 2 TWGs under the committee.
Okay, at ang nag-aproba po nito ay ang
po
Chief Justice.
Yes, Your Honor.
So dito ba salamat po, Justice Marquez. Attorney Gadon, dito ba nanggagaling ang iyong complaint number 4 na aksyon o hakbang ng Chief Justice na nakapagpatagal sa proseso ng pagkuha ng survivorship at retirement ng mga pamilya ng yumao? Dito sa dalawang technical working group na sinasabi mong headed by Jocelyn Fabian.
Yes, Your Honor. Diyan po, sapagkat ang pinagtataka ko ho dyan ay bakit kinakailangan nilang magbutuhan na para silang mga members din ng Supreme Court. No? Samantalang, ang kanilang dapat na gagawin lang dyan, gumawa lamang ng study and recommendation. So, it came to a point na kailangan pa nilang magbutuhan. No? Whereas, hindi naman sila ang final decision makers yan, kundi yung members ng Supreme Court. So, yung pag-aaral na ginawa nila dyan ay napakatagal. Napakasimpleng issue lamang po yan. I-determine lamang nila, totoo ba na may pangalan ng justice na ganito? At totoo ba na ito ay namatay? At totoo ba na meron itong naiwan na survivor? No? Sobrang simple lang ho yun. Kahit nga isang oras, kaya ko i-decide yan eh. Pero nagtatagal ng halos 2 taon. In fact, nakakausap ko yung ibang family ng ng mga ng survivors na yan. At sila nga ay naghihinaing sa akin. At yun na sinasabi nga nila na naiakyat lamang ito sa Supreme Court en banc nung mag-file na ako ng case ng impeachment against Chief Justice Sereno. Nagpapasalamat nga sila sa akin na kung hindi pa raw ako nag-file, hindi pa ito maiaakyat sa kaukulang desisyon ng Supreme Court en banc.
Salamat, Attorney Gadon.
Maraming
Attorney
salamat
Marquez,
po.
balik po ako sa inyo uli. Kasama po dito sa dumaan sa Technical Working Group, Administrator Marquez, yung kaso ng 29 yumao na kompleto naman sa requirements fully fulfilled, hindi po ba?
Tama po.
At yung sa mga 271 na naunang desisyon ng Korte Suprema, ito'y aprobado na.
Tama po. Ng iba't ibang justices ng Supreme Court.
Kaya naman marami ang nagagalit kung bakit ang technical working group na ginawa ng Chief Justice ay dedesisyonan pa ang kaso ng 29 na meron ng 270 precedents of the Supreme Court itself. Yun ang pinagtatakahan ng marami. Yung pagdesisyon sa mga taong hindi kompleto ang requirements, maaring pag-iisipan pa. Pero doon sa 29 kompleto sa requirement, isang malaking pagkakamali, na sila ay husgahan pa nitong technical working group na ito'y ang mga kasong nauna dito, may precedent na dumaan na sa Supreme Court. Sang-ayon ka ba doon, Administrator Marquez?
Well, kami ko po kasi sa Office of the Court Administrator, sumusunod lang po kami sa sinasabi nyo mga presidents or presidents. No? So kung ano po ang naging desisyon na o pasya na ng ating kataas-taasang hukuman, yun din po ang aming ina-adapt sa aming mga recommendations.
Tama po yun. O sino po itong technical working group na upuan ang mga kasong katulad nung mga nakaraan na dinesisyonan na ng Korte Suprema habang nanganganib ang mga pamilya na ito at kailangan na nila ang perang pinaghirapan ng kanilang mga kapamilya. Hindi ba po ganun yon, Administrator?
Maaari po.
Siguro ganun nga dahil dyan kayo ay sumulat na ng isang memo dated October 26, hindi po ba ganun? Tama ba ang mga date ko?
Yung sulat ko po tungkol sa 29 incidents, January 12, 2017 po.
Ayun po. Ang importante, nakita nyo, sa 29 kasong ito, na dati, nadidesisyon na ng mabilis at binigyan na ng desisyon ng Korte Suprema, dati, wala namang problema. Ngayon, inuupuan ng technical working group at yumao na nga ang mga kamag-anakan nito. Kaya naman siguro si Attorney Gadon, ganyan na ang complaint niya. No? Na nagko-commit ng culpable violation of the Constitution ang Chief Justice nung gumawa siya ng mga hakbang tulad ng technical working group na naging balakid sa retirement and survivorship ng mga namatayang pamilya. Yan ang intindi ko. Wala na po akong tanong, Mr. Chair.
Okay, I am supposed to be the next interpolator, but since I am the spare tire of Chairman O'Malley, I may as well proceed already to ask questions. First is Court Administrator Marquez. Klaruhin ko lang po para kasi medyo ang dami ng sinabi, nagiging sabog tuloy pagkakaintindi ng iba. Kasama na ko doon. We have Republic Act 9946 dated July 27, 2009. Alam mo po yun?
February 11, 2010 po. Yung last amendment po.
Okay, February
10 at 11, 2010.
Okay. And basically, in a nutshell, anong sinasabi dito?
Ang sinasabi po dito na pag ang isang huwes namatay, yung kanyang retirement benefits ay makukuha ng kanyang surviving spouse.
Okay. Gaya nung sinabi ni Honorable Congressman Bundok, katulad ng iba pa na magkasama natin, nung ikaw pa ang nagpa-process ng mga claims, wala tayong problema dito, di ba?
Well, opo. Pagkatapos po sa Office of the Court Administrator, dumidiretso po sa sa Office of the Clerk of Court and Bank for raffle to a member in charge. And within 2 to 3 weeks, lumalabas po ang desisyon ng ating kataas-tasang hukuman.
So, magdadaan ito, ang approval is Court and Bank.
Opo.
Kaya, mali yung sinasabi dito ni Chief Justice Sereno na siya or ang Court and Bank ang nag-a-approve nito. Anyway, idediretso ko na. Nung ikaw pang namamahala, ikaw pang nagpa-process ng mga claims, 271 cases ang mabilisan na approve ang claim.
Tama po yun.
Na-actionan ng Court and Bank.
Tama po yun.
And gaya ng sinabi ni Congressman Bodok, matter of 2 to 3 weeks, okay na.
Yan po ang aming bilang.
Until lumabas itong technical working group, which for 2 years, ang claim na process only through this technical working group.
Ang nangyayari po, pagkatapos po ma-process sa Office of the Court Administrator at pagkatapos po namin maisumite sa Office of the Clerk of Court and Bank for raffle to a member in charge, ayon na rin po sa pahayag ng members ng Technical Working Group at ng committee, pagkatapos po namin ma-submit sa Office of the Clerk of Court, nira-raffle din po sa member in charge. Pero, hindi po ibinibigay kaagad sa member in charge. Napupunta po muna sa committee. Unlike before, prior to the creation of the committee and the technical working group, pag na-raffle na sa member in charge, diretso po sa member in charge, na agenda, nagdidesisyon po ang ating kataas-tasang hukuman.
So comparatively, wala tayong problema sa Court and Bank dahil pagdating sa kanila, pag naisalang na sa kanila, ina-approve ang claim.
Wala pong problema. Katulad din po sa nasabi ni Justice Martires kanina, pagkatapos po ma-raffle sa kanya ng August 2017, in just a month, nakapaglabas po siya ng parang 30-page decision po yata yun, no? Mahaba-haba. So in just 1 month, So, hindi po talaga sa court and bank ang naging problema.
So, ang bara, nandun talaga sa technical working group.
Pag tiningnan po natin ang timelines, doon po talaga naipit.
Okay. Nung nandito sina Attorney Fabian, if you can recall, may tanong ako, after the so-called Martires decision, ilan pa ba ang pending claims?
After po sa decision ni Justice Martires, doon po sa 29 na inilista ko doon sa aking liham dated January 2017. Yung 29 claims na po yun, 25 claims po doon ay galing sa mga first and second level courts. As of today, as we hear or as we speak, all 25 cases have been approved pursuant to the decision of Justice Martires. Of the 4 remaining cases, kasi 3 po doon Court of Appeals, 1 po doon Court of Tax Appeals. Ang alam ko po doon sa Court of Appeals, yung kay Justice Colayco na approve na rin po yun. Yung 3, wala po akong notice because hindi na po pumupunta sa amin yan. Dumidiretso po sa Court of Appeals yan. Sa Court of Tax Appeals, wala rin po akong notice kasi dumidiretso po sa Court of Tax Appeals yan. But judging from the 25 or 26 cases, I would like to think that the 3 remaining cases have already also been approved by the court and bank.
During that hearing, inamin ni Attorney Fabian na even after the decision of Justice Martires, meron pa rin nakapending sa kanila.
Ganito po yon. Kasi po yung naging decision po ni Justice Martires ay parang guidelines, comprehensive guidelines. Hindi po yung individual cases. Kaya po, after the decision of Justice Martires, naglabasan po yung mga resolution on the individual cases. Kaya po, yung 25 or 26 out of the 29 that I have stated, lumabas po lahat yung decision on, all approving